Hello students, welcome to lecture on Muslim law. I'm Marjina Sultana, an assistant professor from International Law College, Greater Noida. Today we will be discussing divorce under Muslim law. A marriage under Muslim law is dissolved first either by the death of a party to the marriage or by divorce. Under the dissolution of marriage by the death of the party, if it is dissolved by the death of a wife, the husband can remarry immediately. But if it is dissolved by the death of a husband, the widow cannot remarry before a certain specified time known as iddat. Iddat period expires. And the iddat of the dead is 4 months and 10 days. So a widow has to wait for 4 months and 10 days. But if she is pregnant, she has to wait until delivery of the child. The second way through which Muslim marriage is dissolved is by divorce, and divorce can take place in 4 ways. The first one is the one which is initiated by the husband. Second, a divorce initiated by the wife, and the third divorce is by mutual consent of both the husband and the wife, and the fourth is by judicial decree. The first one, that is a divorce by husband, is of 3 types: talaq, ila, and the zihar. The talaq is again divided into talaqul sunnat and the talaqul bidat. Talaqul sunnat is further subdivided into ahsan and the hasan. Talaqul bidat is also subdivided into written talaq and the triple talaq. The second way of divorce initiated by wife is known as talaq-e-tafweez. The divorce which takes place by the mutual agreement can be khula or mubarat. And lastly, the dissolution of Muslim marriage by the judicial decree is done under the Dissolution of Muslim Marriage Act 1939, and again it is of 2 types. One is li'an and the other is fasaq. The first mode of dissolution of marriage mentioned in the previous slide is the divorce by husband. Under this heading, we would focus our discussion on the most popular form of divorce initiated by the husband, that is talaq. As I have mentioned in the previous slide, talaq is a divorce initiated by husband, and it is broadly classified into 2: talaqul sunnah and talaqul bid'ah. Before we look into the details of classification of talaq, let's first understand what's the meaning of talaq. Talaq means a release from the marriage tie. It is a generic name for all kinds of divorce, but the word talaq is particularly applied to the repudiation by or on behalf of the husband. Coming to the talaqul sunnah, it can be easily understood from the name itself that it is a talaq which is effected in accordance with the sunnah, that is, traditions of the Prophet Muhammad, peace be upon him. And this talaqul sunnah is further subdivided into ahsan, that is the most approved mode of talaq, and the hasan, that is the approved mode of talaq. The word ahsan in the Arabic word ahsan means best, but we cannot say talaq as the best talaq. So the appropriate word is proper mode of talaq or the most approved mode of talaq. The Hasan means good. So this is the approved mode of talaq or proper mode of talaq. But talaq. So Hasan is of lesser worth than Ahsan because Ahsan is the most approved mode of talaq. The another kind of talaq is the talaqul bidda. Talaqul bidda, it is also, it can be understood from the name itself that bidda means innovation. So this and the innovation is the sin in Islam. So this talaqul bidda is the sinful form of divorce. So it is a disapproved mode of talaq, and it is some jurists consider it as the is the innovation within the fold of Sharia, and it doesn't you know it is not neither sanctioned by the Quran nor by the traditions of the Prophet Muhammad, peace be upon him. And it is in the recent case of Shah Banu versus Union of India, it is set aside by the Supreme Court of India, and so it is no more a legal or valid form of talaq in India. Talaq e tafwiz is a talaq initiated by the wife. This is the delegated talaq, that is, such power of the wife to give divorce to her husband is delegated by the husband only. Such power is delegated through an agreement made either before or after marriage that the wife can divorce her husband under some specific conditions, such as if the husband marries a second wife, or in case if the husband is unable to maintain her for a specified period of time, or under any other condition that must not be opposed to the public policy. In this slide, we are going to discuss divorce by mutual consent, and it may be done by khula or by mubarat. Khula is the divorce with mutual consent at the request of the wife. So the essential conditions of khula are that there must be an offer from the wife's side, and the offer must be accepted by the husband, and the third condition is that this acceptance must be with the consideration, that is called ivas, with the consideration for accepting the khula, the request of the wife. The second way of divorce by mutual consent is mubarat. Mubarat signifies mutual discharge from the marital tie. Here, the most essential element is that the mutual consent of both the parties is required in regards to the dissolution of marriage. In this mode of divorce, offer can be made from either of the sides, either from the husband or wife, and acceptance of offer makes divorce irrevocable. Here, the distinction between the khula and mubarat is that in khula, the offer is made by the wife, but in mubarat, it is it can be the offer can be made by either party. In khula, the acceptance is made by the husband, and in the mubarat, the other party, that is the one who is not making the offer, has to accept it. Here in khula, the most important thing here is that in khula, a consideration passes from the wife to the husband, and but in the case of mubarat, there is no question of consideration. The question of consideration does not arise under mubarat. The last mode of dissolution of marriage that we are going to discuss here is by way of judicial separation. And it is done under the Dissolution of Muslim Marriage Act of 1939. It can be li'an or fasakh. Li'an can simply be described as the wrong charge of adultery on wife by her husband. So whenever a husband imposes forced adultery charges on his wife, a wife can sue him and can also obtain a divorce on the same ground under the Act. And it can be done by filing a regular suit for dissolution of marriage. So here the main important condition for li'an is that the husband should charge his wife of adultery, and such a charge must be a false one. The second way is by fasakh. Quran says that husband and the wife are duty bound to respect each other and treat each other respectfully and obey all lawful orders of each other. But if both of them find that they cannot live as husband and wife further lawfully, in an acceptable way that would please Allah, then they can approach Qazi, who, after careful examination, may terminate their marriage. And Section 2 of Dissolution of Muslim Marriage Act of 1939 provides 9 grounds on which a Muslim wife can obtain a decree of divorce. For example, if whereabouts of the husband are not known for the past 4 years, if there is a failure to maintain the wife for 2 years, or a husband is imprisoned for 7 years or more, or there is a failure to perform marital duties for 3 years, or in case of impotency of husband, or there is the husband is suffering from insanity, leprosy, or venereal diseases, or repudiation of marriage by wife, if a girl is married before the age of 15 years by her father or guardian, then under Muslim law she has the right to repudiate such marriage after attaining the age of 18 years, provided that marriage is not such marriage is not consummated. So this option of wife to repudiate the marriage is conditioned on the ground that is this conditional that the marriage should not be consummated. The other grounds for dissolution of marriage recognized by Muslim law is when on the grounds recognized valid under any law, or if the husband is cruel, on the grounds of cruelty, husband can claim for the decree of judicial separation on the grounds of cruelty. So these were all about the dissolution of Muslim marriage, and this is it for this video. Thank you.